Affairs in Order with elder care attorney Robert Slutsky. Rob has been practicing for almost 30 years. We have an office in Plymouth Meeting, we have one in Malvern, and we have one in Radnor. Right now we have been doing Zoom consultations as well as phone consultations, but we're happy to say that our office will be fully vaccinated and we will be able to offer in-person appointments again in the end of the month in May. So if you are interested after this in setting up a consultation, you can have a choice about whether or not you would like to do a Zoom one or do an in-person consultation. And thanks so much for joining us today. We're happy to be a resource to everyone. Thank you to the Monco Retired PSEA group. Please reach out anytime. You have my information from my email that I sent out before, and we'll also be sharing our information as a follow-up from this. Does everybody have their special elder law quiz ready to follow along? Okay, and we have our guidebooks. If you're interested in one of our senior resource guidebooks, you can reach out at any time. Send me the best address to send them to, and we'll be happy to put them in the mail for you. And thanks so much, Rob. Well, you can take over from here.
I'm going to take over from there. Good morning, everyone. Again, Heather already said it, but I'm going to say it again. Number one, I love to see faces. So if you have a camera, and I know you do, please turn it on. Number two, if at all possible, mute yourself only because the background noise can get disturbing to the other attendees. And if you want to ask a question, by all means, unmute yourself and ask. I'm happy to answer it while we're talking. So I have a bunch of topics that were presented to me beforehand, and then if, that doesn't satisfy you, we can kind of go over some of the topics in the elder law quiz. So I'm going to start with stuff that was sent to Carl, and then forwarded to Heather, and then forwarded to me. Oh, good. So the first question was, what are the various types of senior retirement communities? Well, the bulk of the senior type of communities, when you say senior, I'm thinking about care. So, there are over 55 communities which provide absolutely no care, and it's just basically shared maintenance contracts and typically some sort of clubhouse that might have a gym or a pool and a meeting room, but that is basically just independent living without any sort of supports of any sort. It's more of a social model where people just have the opportunity to meet other people who are 55 and older and not have to cut the lawn. And typically, though, they offer first floor master bedrooms so people can age in place. Once you get to care, you're typically going largely in the freestanding care model. So what does freestanding mean? There are communities called CCRCs, Continuing Care Retirement Communities. These are communities in our area. You'll see them in Acts, Meadowwood, Folkways. These are communities where they have all levels of care on the same campus, so that you can transition from one level of care to the next level of care, and it's in a familiar environment, and they're typically more upscale, and as a practical matter, the care quality is usually consistently better quality than you're going to find at a lot of freestanding places. Not that freestanding places are necessarily not good, but with the clientele that you will typically see at a CCRC, they tend to be more well-educated, they tend to be more affluent, and therefore they tend to also have higher standards. And they're usually paying a not insignificant entry fee, so they expect better care, and they usually, frankly, get it. Now, the CCRCs tend to come in two flavors. One is the fee-for-service model. So the fee-for-service model says, hey, you're going to come in and you're going to pay X amount of dollars to purchase your unit. And that unit can be anywhere from a single room to a 2 to 3 bedroom house. And if you go to the more exclusive communities like a Meadowwood, you actually have, Meadowwood is more out there. It's in Worcester. So Meadowwood has a number of, frankly, large, comfortable, freestanding homes that are part of the community. So does the Hill at Weissmarsh. These are, on the more expensive end. So you might pay, depending upon the community and depending upon the place that you end up renting from them, anywhere from, say, $150,000 to $1 million up front to get the house of your choice. Then there's going to be the monthly fee. And the monthly fee is really going to depend, again, on the community and the model. But they will start typically now in the neighborhood of $2,000 to $3,000 a month minimum and go up to $5,000+ a month. So the first model is, again, the fee-for-service model. So let's say I go to a place that has fee-for-service. I give them my upfront fee, whatever that is. My start fee is now $2,500 a month for independent living. And independent living is essentially an apartment, maybe one meal a day in the community dining room, and minimal services. Although, again, you can buy more services if you want them. But you'll pay that $2,500 to $3,000, and you are basically an independent person. You're not getting any sort of care. But in a fee-for-service model, the next level of care is usually personal care. This is where you're starting to get physical assistance, cueing, guidance, assistance with activities of daily living, feeding, bathing, dressing, toileting. There, you will usually see fees in the neighborhood of $6,000 to $9,000 a month, depending upon your level of need. So that could mean if you're just need a little bit of assistance, and you don't need high levels of care, then you might be at $5,000 or $6,000 a month. But if you have significant cognitive impairment and you need a high level of supervision, cueing, guidance, supervision, then you are going to be at $9,000 to $10,000 a month, and that's all out of pocket. The third level typically is going to be the nursing unit. This is the highest level of care. It has the highest required level of nursing services under Pennsylvania law, and it's going to be very expensive. You're looking probably at around $13,000 to $16,000 a month in your average CCRC. Now, most CCRCs are not-for-profit organizations and have what's called a benevolence program. So that means that if you, through no fault of your own, run out of funds. So let's say you walked in with $1.5 million and through a stock market drop and just using the money for care, you ended up running out of funds. Most of these organizations have a benevolence fund that says, hey, we're not going to kick you out because you used all your money to pay us. We're going to front you the money, or at least comp you the care, and all we're going to ask for is your monthly income. Almost all CCRCs, for-profit and non-profit, have this promise. However, the bulk of the CCRC communities in our region are not-for-profit. I don't remember Ann's Choice. I don't remember because I think their parent company went bankrupt and they got bought out by a not-for-profit. I don't remember though. Originally they were a for-profit. I believe Shannondale is a for-profit, so I don't know. I know that they make a benevolence promise. I also know that I have read of a case or two where there was an argument that they didn't go through with it, but that could have been for a number of reasons, and I don't know the reason. In other words, they all require in their benevolence promise that you don't give away your money, and that's a fair requirement, because if you're going to give away your money and then say to them, hey, pay for my care, that's a violation of the contract, for one, but it's also wrong. If you're going to go in there with the anticipation of asking them for this promise, then you should honor your promises. The second model is similar but different. It's called the life care model. So whereas the fee-for-service model charges different monthly fees for every level of care and again provides the benevolence promise, the life care model starts with the assumption that we're going to charge you a higher monthly fee from the start. But as your care needs increase, your monthly fee is going to stay the same. So the life care model is sort of like, as long as you can make the monthly fee, you potentially have a better opportunity to preserve resources for the next generation. But the monthly fee tends to start out markedly higher. Now, though, when I think about the population that I'm speaking to today, you are Pennsylvania retired teachers, which means that you are provided, by most standards, very generous pensions. And I'm not saying everybody here is, but by and large, Pennsylvania teachers have pretty substantial pensions and retirement income, and as a group have been historically frugal in their lives, so they have other savings. So the life care model is kind of uniquely set up for you because you have nice retirement incomes coming in, so you don't really have to worry, unless the Commonwealth files bankruptcy, which is highly unlikely to happen. You guys really don't have to worry that your monthly income that you're using to pay the monthly base fee is going to change dramatically, whereas other people who might be in private industry and are looking at their stock portfolios go up and down on a daily basis, and that's the basis of their monthly incomes, they're going to be more thoughtful about which model they would like to choose. But the one thing you need to understand is that when you go into a CCRC of any nature, they are licensed in Pennsylvania as insurance companies. They're required to hold certain financial reserves so that they have the funds to be able to pay your benevolence, if in fact it is needed. I will tell you that none of the ones that I've ever seen their finances, and typically when a client of mine wants to go in there, I review their finances, none of them have A++ ratings. Most of them are in the B to B+ rating, which means they're reasonably stable. But you do have to understand that just like your long-term care insurance premiums, the monthlies can definitely go up. So if you enter one of these places that has questionable financials, you are likely to see notable increases, because the only way that they're going to be able to shore up their financials and keep their stable ratings is to make sure that they have enough revenue coming in on a monthly basis to pay all of their expenses so that their reserves do not get depleted. So that is the CCRC. And again, that is all levels of care, typically on the same campus, and they typically have overall a higher quality level of care than you're going to find in many places. The next type of care is freestanding fee-for-service. So this is where you have typically an independent living and or personal care either together or separate. In most cases, you have personal care as a separate building. So these are your Sunrises, your Brandywines, your five-star senior livings, your Artises. These communities typically have the one level of care. They are mostly personal care. And to go there, we should probably understand the licensing differences between the four types of licensed communities in Pennsylvania. First is independent living. And again, independent living is largely a glorified apartment. Yeah, they might have one of those pull things that say, if you've fallen and can't get up, pull this and we'll come and help you. But beyond that, and the communal dining room and the social services, which are very valuable and very, a very big part of the whole experience, these are not care. Independent living isn't providing you with care. Now, many of them have care that they can upgrade and give you, or they can move you to their personal care facility, but they are licensed largely as apartments. The next level of care is personal care. And in Pennsylvania, personal care is a very wide variety of potential services. Personal care, in my opinion, the licensing is I'm not happy with it, because personal care takes people who just need a little bit of help to people who are basically nursing home appropriate. And I don't like the fact that the Pennsylvania Licensing Agency allows that, because I feel like if they are going to allow people who have very, very significant needs, they need to have staffing requirements that are much higher. In other words, they leave it up to the facility in most cases to choose to increase staffing if they have a particular resident that needs a high level of care. To me, it should be you don't take those residents as a personal care, or you're going to be staffed. You're going to have staffing at a much higher level every single day of the week. So I have an issue with that. But you will have people in personal care who just need a little bit of help getting dressed and the communal meals and don't want to do their lawn cutting and house maintenance, to people who are completely cognitively impaired, who need a two-person assist to ambulate, who need total assistance with bathing, dressing, and can barely feed themselves. So the personal care licensing is very, very broad, and you have to be very careful when you admit someone to a freestanding personal care, because you need to know that the level of care that your loved one needs is able to be accommodated by that particular building. The highest level, and then we do have what are called assisted livings. Now, most of the places that you see that are licensed, that call themselves assisted livings, are in fact not assisted livings. They are personal care from a licensing perspective. In 2006, Pennsylvania enacted new regulations to allow specifically licensed assisted living communities. The intent was that they would have a little higher level of support and staffing than personal care, but would allow people to age in place and ultimately to access Medicaid funding for those buildings. Anybody who's heard me speak about this before will know that I am still frustrated by the fact that even though we've had this licensing in Pennsylvania, and there are many, many people who end up in nursing homes solely because they have run out of funds, that nobody has ever, no assisted living that is licensed in PA, and there's only a few of them in each county, but no assisted living has ever received $1 of Medicaid. They are approved, the licensing and the regulations are there to allow it, but the Pennsylvania Department of Human Services has never paid a dime to an assisted living. And to me, the assisted living is the panacea. It's the answer to many of our questions, because I have clients who are simply old and cognitively impaired but physically healthy, meaning they don't need that much physical assistance. They need more guidance and they need more cueing. And where they are a funding source to allow them to stay in the less restrictive environment that an assisted living provides, they would be able to live there. And it would also save the Commonwealth of Pennsylvania millions and millions and millions of dollars every year, because they would be paying a much lower reimbursement to an assisted living than to a nursing home. And yet nobody has ever explained to me why that's the case. So why we do have assisted livings, they're few and far between, and they are not Medicaid eligible. Personal care also are not Medicaid eligible. The only institutional source of funding from Medicaid in Pennsylvania are full-blown nursing homes. Nursing homes have much higher staffing requirements, and they require an actual registered nurse to be on each floor every day, 24/7, 365. So this is the highest level of care. It's typically for the frailest population. Freestanding nursing homes, again, are the majority. Yes, every CCRC that we have in Montgomery County or beyond has a nursing home. Probably 70 to 80% of those nursing homes, however, are largely for the community members that are in there. And about 70 to 80% of them, if they take anybody from the outside, it's only for Medicare-covered rehabilitation and not for long-term care services. And most of them do not accept Medicaid funding. So you would be on the hook for $15,000 a month, private pay, were you to want to go into one of them as a direct admit who's not a member of the community. So, when you're talking about the Shannondells, when you're talking about the Hill and White Marshes, when you're talking about the Folkways or the Axe communities, by and large, they are not Medicaid eligible, and they are not accepting long-term care admissions from the community. Only would they accept them from their own communities. The Axe communities are great. They're slightly less expensive than the Meadowwoods and the Folkways. Axe has one Medicaid eligible nursing home. It's their one on Valley Forge Road in Montgomery County and Upper Lansdale. There are other good places that are also CCRCs that are religiously affiliated. Those would be the Mennonite homes, the Doc Woods, the Peter Beckers, Rock Hill Mennonite, Frederick Mennonite. Artman is a wonderful place, but they require a lot of money up front. Great care. They're associated with the Lutheran not-for-profit. But again, CCRC, everything on one campus, 2 models for payment. The rest are the freestanding communities, which are the Sunrises, the nursing homes. Many of them have scattered ownership. The 2 biggest operators are the Medicare and Genesis, and then you have a bunch of smaller companies that are still for profit but own communities. Some are barely passable, some are decent, some are you wouldn't want your worst enemy to be in there. I have my preferred list. Sometimes it changes when someone buys them out, but you have to be very selective when you're looking at long-term care. With assisted living or personal care communities, all you have to do is give a 30-day notice to leave. So there's not really that much of a hassle about moving from one to the other because they're all desperate to fill their beds. When it comes to nursing homes, there has to be a lot more forethought in how you do that because one, many nursing homes are not easy to get into through the front door. You're usually having to get into them through the rehab door. And so there's a lot more strategy and planning when it comes to long-term care in a nursing home because once you're in, they can't kick you out as long as you're not violent and you're following the payment rules. But getting into a decent nursing home is a challenge, I'll be very honest with you. So I think unless somebody has questions about that topic, I'll go on to the next question.
Rob, we do have a question in our chat. For the CCRC model, if you pay the large upfront fee for a unit, do you own the unit? Should you die a few months into the contract, what happens?
Okay. For some reason, Heather, I'm not seeing the chat, just so you know.
Okay.
So I think we've had that issue before. We probably have to contact Zoom. Okay. So each community has their own payback plan. Most of the life care communities have a standard plan that simply says each month that you're there, you amortize 2% of your upfront fee. So by the time you're there 60 months or 5 years, you've lost all of your money. You wouldn't get a dime back. Some of the models allow for a higher upfront fee that you will get a percentage back that goes to your estate. So it's really community specific. I think though most of the life care communities typically take the position that you lose the 2% until it's gone, whereas the fee for service communities tend to have a payback, but you have to that payback it has an asterisk next to it because most of them condition it upon re-renting the unit. So I've had people at a number of places where they were still building new units. Well, if you're coming into a place that's building new units and someone moves out, are you going to prefer to get an old used unit or a brand new unit that's customized for you? So yes, they do it, but sometimes the return of the funds can be pretty delayed. There's a question that just showed up from Jerry Richmond. What are Arden Courts and Artists? Can you explain how the care is covered? Okay. So both Arden Courts and Artist Senior Living are specialized personal care communities. They only accept people with cognitive impairment. They're set up specifically for that. They're designed physically for that. Artist is a company that, as far as I know, in this area only has one or two personal cares. Arden Courts is owned by Manor Care, which has a number. They own Manor Care nursing homes. They also own Heartland Hospice. So Manor Care is a large national company. I'm not going to get into my personal opinions about either company at this point, simply because I don't think this is the right forum for that. I'll simply say that when I represent a client, I give them my frank opinion on places that I prefer, places that I have heard negative reviews on. But those are two specialized cognitive impairment communities. Now, to me, it's kind of when they say, well, it's only, these are supposed to be only for people with cognitive impairment. 28 years ago when I started to practice law, that meant something. Because back then, people went into these communities who were not cognitively impaired, who just needed a little bit of physical assistance. Today, almost no one who goes into an assisted living doesn't have some measure of cognitive impairment. So almost every community, whether it's got a specialized memory care, floor, wing, whatever, they all, 80 to 90+% of their residents suffer from some level of neurocognitive impairment. But these are communities that, when they build the community, they try to build it in a way that is more friendly to people with cognitive impairment and their thinking process and how they work. So these two are specifically only, but as a practical matter, every Sunrise, every Brandywine is going to have people who are cognitively impaired. So Martin says, if you have long-term care insurance, will they pay for unlicensed caregivers in your home? when you say unlicensed caregivers, I mean, if they're not through an agency, I would doubt it, whether your long-term care insurance would pay for that. But there are some policies that simply don't discern. Basically, there are some long-term care policies that say, if you meet the definition, we're going to pay you the benefit. We're not going to worry about where you're buying it. There are some policies that say that. You meet the definition, you cannot perform 2 ADLs, or you have significant cognitive impairment that we can confirm, then they might just pay the daily or monthly benefit. But I would think that a lot of the providers of long-term care are going to want to confirm that you are using a licensed agency, but not every single one. So it's really going to depend on your specific policy. When you buy a long-term care insurance policy, this should all be set out and defined and clarified in the policy itself. Do artists or RN receive Medicaid? They do not. They are licensed personal care, and personal care communities are not eligible to receive Medicaid. Okay. So it says, what are the pros and cons of transferring home ownership to your children? How do I protect my home and assets from nursing home costs? Okay. I can answer that first question. When you ask me, how do I protect my home and assets from nursing home costs? That's just so client specific and so broad a question that it can't be addressed in this form. But home ownership transfer is a really interesting topic because so many people really don't understand the full risk of it. First, most important, if you transfer your home to your kids, it's not your home anymore, right? It's not yours. You've given them the home. So immediately, the first question you need to ask is, how comfortable are you that whoever you transfer it to is going to allow you to stay there as long as you want? It hasn't happened many times, but in my 28-year career, twice, I have had a client come to me and say, I want to transfer my house to my son for $1, or my daughter, who I don't remember if it was male or female, which is irrelevant. And I, of course, give them what we lawyers call a CYA letter. You can figure out what that means. And in that CYA letter, one of the things I say is, hey, client, before you do this, understand that when you make a completed transfer of the deed to your son or daughter, it's their house. That means they can kick you out. Now, again, 99% of the time in that 28 years, never been an issue. The kids are good people. They take care of their mom or dad. They love them. No problems occur. Twice in 28 years, I've had the parent call me back 5 years later and say, my son or daughter is trying to kick me out of my house. And I'm like, go back and look at the letter. I mean, I don't say it because I'm thinking that, though, because I don't want to hurt their feelings and already, compound the feelings that they're already having. But I'm like, I'm very sorry, but you gave them the house knowing that this could happen. And they're like, well, but my son is married to this or my daughter is married to that, and they hate me and they want to kick me out and this and that. So the single first most important concern that you need to address yourself is that you have to have 100% confidence that as long as you want to live there, that the family member to whom you are giving the house in an unrestricted fashion is going to honor your desires to stay there as long as you want. The second, and to some extent that can be alleviated by what's called a life estate. But a life estate isn't a completed transfer. However, a life estate can be used as an asset protection tool. Again, depends on the individual. Another issue that you come up with is the loss of a significant tax benefit. So you own your house and you bought it 35 years ago for $100,000 and now it's worth $450,000. So let's assume that you are two spouses who jointly file your tax returns. Under Section 121 of the Internal Revenue Code, the two of you each of you has a $250,000 capital gains exclusion on your primary residence as long as you've lived there for at least 2 years. So if you were to sell that house in your name alone, the $350,000 in capital gains would be wiped out because you have the two exclusions totaling $500,000. However, if you give that house to your son or daughter, and they later need to sell the house, they are going to pay capital gains tax on that $350,000 increase in value because it is not their primary residence, and therefore it's considered an investment property for them, and they will pay up to 20% capital gains tax on that $350,000 in gain. So you're looking at almost $100,000 in taxes that they could pay by simply transferring it to them and having them sell it because it's not their primary residence. The third concern that I will tell people is creditors. Okay? Now, your son, your daughter, their spouse, all great people. They're not going to kick you out. They love you. They care for you. They're loyal. They're honorable. They're never going to do that. Through no fault of their own, they end up in a car accident and have a $2.5 million judgment against them. Your house is now their house. Their house is now subject to their creditors. So despite no fault of your own or that of your children, their $2.5 million unpaid judgment can be satisfied with the house you are living in. On a lesser scale, depending upon what the child does with the house after it is transferred to them, divorce, other issues could come up. So there are things that can be done if someone wants to look forward a number of years and talk about the use of irrevocable trusts and asset divestiture planning, meaning getting rid of certain assets long before you need Medicaid. But I generally prefer using a trust as the tool because I can put protective provisions in the trust, checks and balances, so that the likelihood of you being kicked out of the house you are living in is much smaller. But whenever you think of transferring assets as part of a planning, scenario, you have to consider all of the options and have to consider all of the potential problems that can occur. Okay, excuse me. So that kind of answers that other question. How do I protect my home and assets from nursing home costs? Home and asset protection really is very individual because you're looking at, I've got to think when you come to me, is care imminent? Because if I'm looking at asset protection, we're essentially saying, I want to access Medicaid long-term care services in the future. I want to structure myself so that I can protect my spouse or my children and have Medicaid pay for my care down the road. When we're doing that, it really is a very individual type analysis because I'm looking at the assets that you have, not just the volume or amount or value, but I'm looking at the type of asset. Some assets are easier to plan with than others. I'm looking at your support system. Do you have 4 children that all live locally that could chip in and kind of help you out if you need care? Or are all of your children dispersed around the country and they love you, but they're not really able to care? Or maybe you don't have any children at all. So we look at that. I, again, look at the nature of the assets. How much of them are retirement plans, where divesting them means cashing them in and paying an enormous taxable amount? What do you have as far as long-term care insurance? If you have it, don't you have it? What's the benefit on it? Do you have a spouse? There are planning tools that I can use when there's a healthy spouse in the community versus someone who doesn't. Do you have disabled children or grandchildren? They allow certain planning options. So it's a very factually specific plan. And what I do is I analyze all of those factors as well as family dynamic and support system, and then I make recommendations to say, here are your options, and you tell me what works best for you based on the options I'm providing. Okay. Does that, okay, I see a question. You keep mentioning Medicaid, which is, I believe, for low-income folks. Does Medicare pay for nursing home? Okay, so Medicare is health insurance for people who have paid into the system and who are over or age 65 or over or disabled under federal law for at least 2 years. Medicare is generally considered an entitlement, meaning almost everybody gets it. However, if you haven't paid into the system, you won't get it. But Medicare does not pay for long-term care. Medicare only pays for medically related nursing home rehabilitation. So if you've ever had an injury, like a broken hip or a broken arm or something, or a condition where you decompensated and then needed to go to a nursing home to get physical therapy, occupational therapy, rehab, whatever it is, the nursing homes are really set up as two separate buildings, but within the same unit. Medicare will pay for up to 20 days of rehabilitation completely once you paid your deductible, and days 21 to 100 they will pay for care in a nursing home for rehabilitation with $170+ copay daily. After day 100, whether you are still benefiting from the rehabilitation or not, Medicare stops paying. They don't go any further than that. After 60 days of not using those rehabilitation services, the 100 days gets replenished. But you have to be out and not needing those services for 60 days, and then you probably have to get a new event that brings you back into the skilled unit of the nursing home. But the important thing is, Medicaid is for people of limited resources, but the two benefits are different. They have a normal healthcare insurance that pays for hospital, doctor, dental, eye for people of relatively minimal assets and income. The long-term care insurance allows higher amounts of assets and more planning tools, and that's the one that I deal with every day. So it's not uncommon that I have clients who have what we consider middle-class assets, who have, say, a house in the suburbs that might be worth $400,000 to $600,000, and say $400,000 to $600,000 of other assets, and I'm able to protect a good chunk, if not most of those assets, depending upon the client, for the healthy spouse, and get the sick spouse one Medicaid for nursing home or home care. However, the home care benefit requires that the applicant have an income that is under $2,382 a month. So often teachers will not qualify for Medicaid in the home because their income tends to be above that when you consider their Social Security and their pension. However, they may have a spouse who's not a teacher who doesn't have significant income, and therefore that spouse, we can often get Medicaid for home and community-based services that will provide, say, 6 to 10 hours a day of assistance. But typically, a lot of people are getting Medicaid in nursing facilities in the non-skilled or long-term care unit. So the skilled unit is where they treat the people needing rehabilitation under Medicare, and the long-term care unit is where they have the residents who are simply too frail and are not rehabbing, but they're just getting care to assist them with their activities of daily living. Okay, let me see here. Okay, so Martin sent this question that was already sent, and I will, let's see here. I think that this dovetails with another question that I was sent by Carl. So I'll try to address that, and Martin, wherever you are, if I didn't give you a full answer, by all means, chime in, and, I'll try to make it more expansive. So the question is, when two partners are living together unmarried, and this comes up a lot more today, simply because of a change from our society and relationships and things like that. So, it's very dependent on the personal relationship. One of the things that I will often recommend is that, if you're partners and have been together for a long time but have vastly disparate financial situations, if you are concerned about the obligation to pay for the care of your partner, don't get married. Because when you are married, Pennsylvania and federal Medicaid law looks at you as a single financial unit. And for people who have more modest assets, this might be better because it allows me to protect a lot more resources for the healthy spouse. Whereas if they're unmarried and I have a spouse or I have a partner who has a lot more resources and really wants to give it to their less wealthy partner when they go into a nursing home, they can't. That will be considered a transfer without consideration and trigger a very aggressive draconian penalty for giving money away. Whereas if you're married, there is no asset transfer penalties for married couples prior to eligibility of the one partner that is eligible. So when I have someone who has vastly disparate financial situations and they're unmarried, the poorer, for lack of a better description, of the two partners is more likely to be eligible for Medicaid relatively quickly. And that would protect the assets of the wealthier partner. So it's again, like everything else I do, it's very specific to the client, because some may say, well, I don't really care. I want to be married, and that's important to me, and I care. And there may be other people who say, well, I have a pretty healthy background, and my parents both died, at 85 years old without any dementia, and therefore the likelihood of me needing long-term care is relatively nil, but I want to minimize the inheritance tax, because if I leave money to my spouse, it's a 0% inheritance tax in Pennsylvania, but if I leave it to my unmarried partner, it's a 15% inheritance tax. So I might say, which is the bigger risk? Me blowing through the money for long-term care costs, or me having to whack my loved one, who I dearly want to get everything possible, with a 15% excise tax on anything that I give to them after I die? So you have to think about that. I'm trying to figure out what I should answer. The next question on here or the next question on the chat. So let me see here. Can you explain? Sally says, can you explain how we might qualify for Medicaid? Well, Medicaid is a means-tested program. So if you're going into a nursing home, income is irrelevant, but assets are. So without getting into all the gory details, there are what are called available resources in this pot, and then there are what are called exempt resources in this pot. And the job that I have is I help clients maximize exempt resources and convert available to exempt. The biggest exempt resource is typically the family home. The government says you can keep that, and they don't have a cap on the value as long as the parties are married. A car is protected, burial reserves are protected, and there are certain other assets that are protected for the healthy spouse. When you look at available resources, the healthy spouse is allowed to keep half of the available resources as of the date of entry into the nursing home. However, there's a cap of $130,000. So let's say that you have a house and $400,000 in a stock portfolio. The government will say, spouse, you can keep the house without any penalties, and you can keep $130,000 of the $400,000, but you have to spend the remaining $270,000 for something, for care or whatever. A lot of what I do is restructuring that $270,000 so that it in fact doesn't look like $270,000 and benefits the healthy spouse, and still gets the other spouse on Medicaid. So that's what a good elder law attorney is going to do, as well as a really good elder law attorney is going to look at what the preferences of the family are. Because this is not just about money. What I do is about people and trying to carry out their wishes and priorities. And money is a piece of the puzzle, because none of us wants our partner, wife, husband, whatever you want to call them, to end up being destitute as well. And the law gives us options at this point to protect that spouse or other family members. If a spouse is living in a nursing home under Medicaid and gets a one-time inheritance of possibly $100,000 between him and spouse, will he be kicked off Medicaid? Okay. So when you say gets $100,000, if he is, let's say that husband is in the nursing home and is eligible and on Medicaid, and Medicaid has been paying his bill. If wife gets $100,000 inheritance, no harm, no foul. It does not affect husband's Medicaid eligibility. Once the spouse in the nursing home is deemed eligible, they are considered divorced for Medicaid purposes, with rare exception. So Medicaid no longer looks at the spouse's assets after that time. If the $100,000 gift or inheritance is in the name of the institutionalized spouse who is a Medicaid recipient, then this will make that individual ineligible. It doesn't mean that we can't do some stuff with the money, but it does mean that they are now ineligible because they have exceeded their protected share of resources, which for the applicant is either going to be $8,000 or $2,400, which means that they'll be knocked well over that. It doesn't mean that we can't do some creative spend down planning, but it does mean that if the inheritance comes in the name of the applicant's spouse, they are going to lose eligibility. So some other questions that were sent before the presentation. So it says, common situations. The house is owned by one partner, not jointly. So there's a couple things you can do about that. One is you can, if they're not married, you can transfer it, but if you do transfer half ownership to the other partner, then you're looking at potential realty transfer tax because they're not an exempt party. And, then you have someone who owns it. Then you have to consider how it's going to be owned. Is it going to be owned joint tenants with right of survivorship, tenants in common? I'm not going to get into make this a real estate course, but there are different implications to how that works. Another option would be to give the other partner what's called a life estate, which is a right to live in the house for the remainder of their life. That has its own complications from a number of different perspectives, but it is one tool to guarantee that the partner has a place to live. It can be put in a trust under your will that can have similar type provisions. But again, the law gives rights to married couples. So, I have a presentation that I do for professionals, and it's about planning for what are today much more common, but historically, non-traditional relationships, where people are not married for whatever reason. The law doesn't care, as far as property, about your gender identity, your sexual preference, who you want to live with or not. The law only cares about contractual relationships. So when I talk about this has nothing to do with your personal lifestyle or anything else. It only has to do with the potential for contractual relationships. The law looks at the ownership between two adults. They don't care about anything else. And that's the way I look at it. And that's the way you have to look at it when you're thinking about it, because these are all basically contractual financial relationships and have nothing to do with how much you care about the person or their gender or their identity or anything else. It's really about what's the situation. And today we have a lot more situations than we did 50 years ago. It's the growth of our society and the changes, and that's all good. But what we need to do is we need to critically analyze that individual partnership, whether it's based on a contractual relationship like marriage, a non-contractual relationship like we just love each other, or a pseudo-contractual relationship where we don't get married, but we enter into a contract that specifies how we want property to be dealt with under certain circumstances. So prior to same-sex marriage being legalized in Pennsylvania, I've always had a diverse client base. I had a lot of gay clients. So the gay clients would come to me. And one of the things, if you were a lawyer who dealt with gay clients, is you always explained that if you're going to buy a house together or own a bank account together, you guys need, or you gals need, to have a contract that says, if we ever decide to separate, this is what we want to happen. Because that avoids conflicts, and it avoids lawyers getting involved and charging tens of thousands of dollars to extricate yourself from a relationship that doesn't work anymore. It's always best to engage and to look at problems while you're still friends. To look at the worst possible scenarios and say, hey, we love each other now, so let's think of what we would want to happen if we no longer loved each other or wanted to be partners anymore. And it doesn't assume you hate each other, it just assumes you no longer want to be contractually bound. So what I tell people is think 2 steps ahead. And whether that's what are they, a cis or heterosexual couple today, or whatever all the names are. I admit I'm old, I don't know all the different names. But the point is, look at your relationship, try to define what you want in an agreement, and then put it in writing regardless. Now, if you're married, the government gives you certain contractual rights. And if you're okay with those rights, more power to you, that's cool. But if you have an unconventional or non-traditional relationship where you're not being married, then you're kind of out there as two totally individual people, and there's no protection. And you want to then think ahead of things that can go wrong and fix them, so you save time and money. What if one partner is several years younger than the other? Well, I don't know what the term several means in this context. To me, several years younger is very common. It's very rare you find someone who was born on the exact same date you were to fall in love with. So I don't think about that as a particular issue. What I think about is May-December romance, where you have someone who's 15, 20, 25 years difference in age, because that does make a difference. Because if you have a spouse who's 60 years old and their partner is 85 years old, we have to think very specifically about how we're going to preserve enough resources so that if the 85-year-old needs care, the 60-year-old is not stuck in a position where all the money has been blown and they've got 30 more years to live with no money. So that matters. Again, I mentioned the issue of one partner has considerably more savings than the other. And again, if you're married, that's a different discussion. If you are in a marriage, which many people are today, where assets are largely held separate, I would recommend either what's called a pre- or post-nuptial agreement, where you kind of say, this is what we have. I will say that when I'm doing planning today for people of what I would say is my generation, so I'm right before the boomers, I would say, up until 60s, early 60s, I find that probably 50% or more of the people that are coming are a second marriage. And therefore, one of the things that we talk about, and I will tell you that in the last 2 days I've talked with 2 different couples about it, is the use of a post-nuptial agreement. Because while the couple are very committed to each other and often have been together for 20 plus years, they have children from prior marriages. And they want to be equitable in the distribution of the funds. And how do you do that if one spouse dies at a relatively young age and then the other spouse inherits all of the money and may consider remarrying? Because, I have a couple I just was dealing with this morning before our presentation, and they've been married for 25 years. They have 2 children together, and he has a stepdaughter from a prior marriage who he's very close to. It is very evident that 95% of the couple's assets, however, came from the wife. She is a corporate attorney working for a large pharmaceutical company. She has stock options. She has a large 401k. I will almost guarantee you that 90% of the assets that are part of this marriage, he makes literally 1/10 of what she does. All the money is hers. And therefore they have, and he wasn't in any way difficult about it, but she wants to make sure that her 2 daughters get the vast majority of the funds if they die. So we are putting together a post-nuptial agreement where he is basically bound by their planning, and the only way that the planning can change if she were to die early, and there's no reason to believe they're both in good health, but if that occurred, then he would actually have to get the permission of his 2 daughters before making a change in his asset disposition. Because, look, these are assets that were largely accumulated during their marriage, and in this case, largely accumulated by her. So it's only fair for them to have something binding both of them to take care of the children. But it works both ways. He wants his daughters to be taken care of as well. So if he dies first and she enters into a new relationship and all the money is in her name, she would need to get the permission of her daughters to make a large change in the plan. So pre- and post-nuptial agreements are great tools to avoid conflict down the road, because this is why you're still happy, in love, friendly, and you're simply saying, what if, what if, what if? How do we avoid the conflict down the road? And I believe that I just answered the next question, which was both partners have adult children from previous marriages and also young grandchildren. And again, I think that is the same answer. You use the tools that are given to you under Pennsylvania law, which is the use of a pre- or post-nuptial agreement, also sometimes called a contract to make a will, because you're basically agreeing not to change your will disposition, or in my case, I also wrap in non-probate dispositions like beneficiary designations on your 401k or your annuity. So I wrap all of those in so that someone can't be sneaky and give away money while they're alive to get around the agreement. So let's see here. What do I need to know about guardianship planning? Okay, good question. Guardianship is a tool that people use. With that, if we talk about guardianship, we really have to talk about powers of attorney and other tools for advocacy, because essentially all of these are tools to allow someone who you trust, or maybe not, to make a decision for you if you can't make decisions on your own. So the simplest tool we're going to use in planning, and every client of mine is going to get one, or you're not going to be a client of mine, really, honestly. Because if you don't think a power of attorney is necessary and you're not willing to do one, then we're probably on different planes when it comes to proper planning. So the power of attorney is a document that's drafted to allow medical or financial decisions to be made by another person. And it can be as broad or as specific as you like. Ideally, if you're using it for planning, you want it to be a very broad document that covers everything, so that the person doesn't need to go to court and get a guardian appointed. Because if you are incapacitated, unable to make safe decisions, and you don't have a power of attorney that lists someone to make appropriate decisions, the likelihood is you are going to end up in court in front of an orphans court judge, and that judge is going to have to determine A, if you're incapacitated, and B, who the judge thinks is best to make decisions for you. Now, that may in fact be the same person that you would want as your agent under power of attorney, or it could be someone the judge believes is better because you haven't made it clear by drafting a power of attorney and naming someone. Because under Pennsylvania law, if you have named a trusted individual and later need a guardian, the judge is bound to consider the person you named as your agent first. So you've expressed your preference simply by putting that in the power of attorney. However, if you haven't named someone in writing to make decisions for you, the judge doesn't know your preferences if you are now too far gone cognitively to articulate your wishes in a proper manner. And therefore the judge is then forced to guess. And the judges are well intended, they want to make the best decision for you, but it's always better when you make your wishes known, because the more you express, the more likely your wishes are to be carried out. So power of attorney can deal with financial issues, can deal with general healthcare decision making, and the healthcare power of attorney can also include, and most do, a provision for end-of-life decision making, also known as either a living will or better known as an advanced directive. And this directive says, hey, if I'm in a condition where the doctors have essentially written me off, they've said, look, no matter what we do to you, you're going to die within a reasonably short period of time, no matter how aggressive the care is. This is where you have the opportunity to say, hey, doc, I don't want aggressive, painful care. If I'm in really bad shape, to me, quality of life is important. So give me enough drugs to keep me comfy and treat the symptoms of my condition, but don't aggressively treat the condition. Don't prolong the dying process if dying is inevitable. Okay? So that's what your living will says if you want it. Some people have very strong opinions that they want every single thing that medical technology allows, and that's your personal choice. Most of my clients, however, have had a loved one or a friend go through a very difficult dying process and have made it very clear to me that it is not their intention to linger. To them, to most of my clients, quality of life, the ability to interact with their loved ones is the most important thing, and if they can't do that, they really don't want to be a member of the living. So when you say guardianship planning, basically the most important guardianship planning you can do is have a an in-depth discussion with your lawyer and your family, and choose advocates. Name them in a written document. Make sure that that document is as comprehensive and overarching as possible, so that you don't need a guardian simply because you neglected to put in a power that they may need to exercise in your favor, and address that, get that document executed properly, and have that document available so that if and when you need the help, they have the ability to help you. That avoids a guardianship in about 80% of cases. 20% of cases, unfortunately, are not going to be able to be prepared or avoided with a power of attorney, simply because some people, when they are cognitively impaired, they lack insight. So they do not understand that they need the help, and they start to do dangerous things. and you can't reason with them, and they don't get it. So you're forced to get a guardianship, even though they may have appointed someone as power of attorney, simply because they will not cooperate with their agent and undermine the ability of their agent to help them. And in those cases, which probably is about 20% of the people out there, they will need a guardianship. Maybe it's less. Of course, in my practice, I see a lot more guardianships because I represent the Montgomery County Office of Senior Services, which has their Older Adult Protective Services unit, and I've represented them for 22 years now. And as a result, I see the cases where the fix can't be done without a guardianship. So I probably have a slightly skewed viewpoint because I see the worst of the worst, and I do 50 plus guardianships a year as part of my practice. But for my clients, one of the most important things is get a good power of attorney, name a person that you have confidence in, and talk to them about your wishes. That's the most important thing. When people hire an attorney, the documents are less important than the conversation. It's the education and the experience that I have, having done this thousands of times over 28 years, that's more valuable than any piece of paper I'm going to give you. And then part of that is my wife and I have no children, relatives, or younger friends that we can look into to make future decisions on our behalf. And if we can't do it, what planning and actions? Well, yes, certainly we want to start with family and friends and other normally trusted parties in our life. If you don't have any of that, there are professionals who will act. So I deal, again, in my practice with a number of people who are geriatric care managers, who can be medical advocates. I also deal with bill-paying companies or organizations, individuals typically, who can act as your financial agent under power of attorney so that they can make sure your bills are properly paid, your assets are properly managed. They are not financial planners. They would still go to your financial planner that you've chosen and, take that person's advice for the management of your assets. But in general, they'll make sure that your bills get paid and that you are, and having someone like that as a backup is also kind of a tool to guard against financial exploitation. Because one of the things that I see on a regular basis, when someone has very, very mild impairment, you might not know that your friend Ralph is having challenges when you see him at the Wawa, because he otherwise is able to pick out his sandwich and his coffee and pay his bill when he leaves, and you think Ralph is just fine. But Ralph is suffering from the very early signs of neurocognitive impairment, which used to be called dementia. And what happens is Ralph goes on the internet because Ralph's a little lonely, and he gets into a chat room, and what appears to be a nice woman starts to chat with him. And a couple weeks later, Ralph is writing a $68,000 check to this nice woman in the chat room, and they're friends now. And you ask Ralph, and Ralph says, I'm in love with her, or something to that effect, or I want to help her. She said she has cancer and needs the money for her treatments. And I, as both attorney for the Office of Protective Services and in my private practice, have seen people wipe out their entire net worth, some in excess of $500,000, just sending checks to strangers. And if you have no family, just keeping in touch and having a weekly or monthly meeting with your agent under financial power of attorney could stop that, because they could see, oh my God, Ralph wrote a check. I need to work around so that Ralph can't do that again. So these are both people who can just help you because it's their job and they get paid for it, but they're also there to potentially avoid you wiping out your entire net worth to these very sophisticated scammers that often start out online, but then they get your cell phone number and they call you 1,000 times a day, and they manipulate you and coerce you into giving money away. And you're all intelligent people, and it could happen to you. It could happen to me, because this is at the very earliest stages of cognitive impairment is when you don't recognize that you're having these problems. You lack the ability to self-assess. And as a result, that's when you are most vulnerable to this. Once people are more cognitively impaired, it's harder because they become more paranoid and they lack the cognitive ability to enter into these transfers of relationships. They can't go to their bank and say, wire $100,000 to this bank. They don't have the ability to do it anymore. It's that very first stage. And I say it because I had a son and daughter come to me, I think we're probably 2 years ago in Bucks County. Dad worked at a pharmaceutical company, had retired because he had to because of early cognitive impairment. Yet he was driving a Lyft, like an Uber. He was driving a Lyft. The kids found out that he had wiped out his retirement plan, which was, I think, something in the neighborhood of $400,000, and had written checks of all of his other assets, and had actually extended the equity loan on his home, and written all these checks. And it was only through the kindness and help of federal authorities and the Middletown Township Bucks County Police that we were able to preserve any of his money, because we found out through the mailboxes, etc., where he had put $68,000 in cash in a UPS envelope to send to Houston. The UPS people were able to stop it in transit and return it to that store. As the children were sitting in my 1.5-hour consultation with them, talking to me about this, the store owner called them and said, what do you want me to do? Your dad has been circling the store. He wants this money. We're stonewalling him, but we can't do it forever. It's his money. Thankfully, the police in Middletown Township, where the mailboxes, etc., was located, were willing to go there and say, give us the money, it's part of our investigation. And the federal authorities intercepted another $23,000 packet of cash. But that was all this guy had at that point. He had blown $500,000. But this guy was still driving a Lyft. He could still have a conversation. If you met him, you might not even pick up that he had cognitive impairment, because everything else he was doing, he was eating, taking his meds, he was otherwise reasonably healthy. And that's the scariest part, because any of us on this call, me at 55, some of you at 55 or younger, some of you are 55 or older, that little switch could move in your head, and you don't know what's happening, and you could be vulnerable. So I say, if you don't have the family support, if you don't have the friend support, find a professional. They exist. Heather, what's the name of that terrible movie that was on Netflix?
Oh, I Care a Lot.
Have people seen that, heard about it? Okay. I'm going to say, and I only saw one person raise their hand. Is there more than one person who's seen that or heard that? I Care a Lot. I see Nancy has her hand up. It doesn't seem like anybody else. Okay, and Gail does too. So I Care a Lot is a Netflix movie about, which has some truth to it, don't misunderstand, about a professional legal guardian who essentially finds wealthy or affluent older adults, and in conspiracy with a doctor has them declared incapacitated and essentially wipes them out when they don't really need the help. That is not consistent with my experience with professional guardians. There was a situation, I believe it was Arizona or Nevada, I don't remember, where that actually happened. But I want to tell people that, because I do this every day, and I know a number of professional guardians, and these are people who work hard and do the right thing and generally get paid terribly to do the job. Because generally, unlike this show, most of the people who need guardians and who get a professional don't have any money to take. So, while it may have been entertaining and racy, it is not a true representation of the guardianship process in Pennsylvania. And I say that only because typically the people who act as professional guardians will also act as powers of attorney for people who don't have a family or support structure. So I want to be very clear about that most of the people who do this are in fact honorable, decent people and will do the right thing. Yeah, every business has crooks in it. There's no question. And there's there's certainly people who take advantage of the elderly. Don't get me started there. I mean, protective services in Montgomery County gets in excess of 10,000 calls a year. So definitely there are people out there taking advantage of the elderly. But the people that we have vetted through the county and that I've had relationships for 15 plus years are good people and honorable and would never do anything inappropriate. So whoever wrote that question, because I don't know who that came from, it was forwarded to me by Carl. I would be happy to give you referrals to people who can help you as a support service. I've done it for other clients who are who don't have that and have the resources to pay, because you will be paying them for their time, but it's not an extraordinary amount of money. Philip, did you have a question? I thought you raised your hand. Philip Smith.
I was scratching my head. I'm sorry.
It's okay. You're welcome to
Just
do
answer
that. By
my
all means.
question. I submitted that question that you answered.
Oh, that was your question. So if you want afterwards, Heather's going to give you contact information. If you need that assistance, I can give you some names that you can interview and decide if you want their help. Okay.
Thank you.
You're welcome. How do I leave money in a trust for someone? Well, trusts come in, many flavors. So, but I'll just give you a very brief overview. So trusts can be either what are called inter vivos, just means you create them while you're alive, or they can be testamentary. They can be created after your death. They can be, and you can have an inter vivos trust that you don't fund until after death. So you have inter vivos, and then you have testamentary, which is after death. Then you have revocable versus irrevocable. A revocable trust is what you've all heard of as a living trust. Basically, you can put assets in it, you can take them out, you can amend the trust, you can terminate the trust. Essentially, assets that are in a revocable or living trust are yours to do with what you want. They have no different tax or creditor effects than if the assets were in your own name. Irrevocable trusts, however, are used for different purposes. An irrevocable trust is typically one that, by its name, is irrevocable, which means once you put an asset in that trust, you generally can't get it back out. Once you create the trust, the provisions, and the beneficiaries, you can't change them yourself. So they have different asset protection and tax provisions and protection availabilities. So again, you have to talk to the lawyer about what your goal is. In other words, why are you leaving their money in trust? Is it because they're a minor? Are they irresponsible with funds? Are they incapacitated? Are they developmentally delayed? Are they receiving public benefits that you don't want to jeopardize by giving them a large amount of money? You have to figure out what you're trying to achieve, and then I can say whether a trust is the right tool. But typically, I do a fair number of what are called testamentary trusts, meaning in the will, if you have a disabled child, I can set up a trust for that child so that they can benefit from your largesse and love, but it won't affect their Medicaid and their SSI or supplemental security income benefits, which are means-tested benefits. So I can set it up so that money can be used for them, but it won't be in their own hands, and therefore won't affect their benefits. You can also use trusts for tax reasons. If you have an exceptionally large estate and you want to do what's called a dynasty trust. I don't do a lot of them because most of my clients don't have the $30+ million of assets that make that something worthwhile. You might have a charitable trust which has some tax benefits and then leaves money either on the front end or the back end to family members. So trusts can have a variety of different purposes and can be established either while you're alive or after you pass away. And again, it's a very individual. It's best not to ask about the tool. It's best, to say, this is what I want to accomplish, Rob, and then I can give you the tools and the options to get you where you want to go. For a sibling that is not a power of attorney, what rights do they have to examine expenses? Does the POA have exclusive rights over medical decisions? Okay, so if someone is named, if you have a sibling and someone else is named as their agent under power of attorney, for those particular decisions, they are the ones who have the exclusive rights, other than the individual themselves. Because a power of attorney never takes away your individual right to make decisions on your own. So let's start with the concept that you're always able to be your own advocate. That's number one. And if you name someone as agent under power of attorney, and you don't name another sibling, then the agent that you've named has the exclusive access to your finances and generally to your medical decisions. That being said, but that assumes that you are not still advocating for yourself. In other words, let's say I name my brother as my agent under my medical agent under power of attorney, and he talks to the doctor, and I disagree and say I don't want that. Well, I'm still the boss, but he is still at a much higher priority than my other brother, who might love me and I might love him, but I didn't name him as an agent under POA. So the doctor is not, essentially, if there's a written document, the financial institution and the medical institution is going to listen to whoever's named as agent. And you're kind of, if you're not named as agent, you really don't have any rights there. If there is no agency on the healthcare side, Pennsylvania law has the healthcare representative law, also known as Act 169. So if you haven't written a healthcare power of attorney, then two brothers would probably be, assuming that there isn't a spouse or children, the two brothers or the two sisters would be at an equal power level, and therefore, if they are in disagreement as to a healthcare decision, and I'm not overruling either one of them, then technically the two of them are going to have to fight it out in front of the judge, because the doctor isn't going to get in the middle of it. If you have two brothers fighting over their sister's healthcare needs, and the sister has not named either one of them written as a healthcare decision maker. Let's see. Do children or grandchildren pay PA inheritance taxes on assets received through a trust? Depends on the trust. So if it's a testamentary trust that's created under your will, they don't pay the inheritance taxes, but the executor of the estate will pay them, because they will receive the inheritance in trust net of all administrative expenses. If you could set up technically an inter vivos trust that's irrevocable, and if it's funded more than a year before death and there's no strings attached, technically there would be no inheritance tax there. But again, there's ups and downs to everything. There's no free lunch anywhere. Any decision you make that is going to have countervailing goods and bads. So it's very much about your situation. Because let's say you put $1 million of stock in that trust that's avoiding inheritance tax. Oh, well, you're saying I've avoided inheritance tax, but if the stock is highly appreciated, you won't get a step up in basis based on the way that trust is structured. Because if it doesn't go through your estate, it doesn't get the step up in basis. And you bought the stock at $100,000, it's worth $1 million. It's $900,000 in capital gains tax that your grandkids are now going to pay tax on because you didn't want to pay 4.5% inheritance tax. Sometimes that's not a good choice. So it's about the individual factual situation of what you're trying to achieve.